pull that, if I may. And I'd like to go ahead and do SB 1256.
Very good. So we are, file item 6 is being pulled, and we are at file item 12, the Civility and Litigation Act. All right. SB 1256. Good afternoon, Senator.
Thank you very much, Madam Chair, members. This measure is intended to begin bringing civility back into our legal system. As a matter of public policy in judicial resources, settlements and resolution of disputes in full and fair hearings of claims is to be encouraged. Regrettably, too often we see drive-by lawsuits, harassing and many times and frivolous, have become a way of life for small businesses and individuals, stifling productivity, clogging our court system, and wasting precious judicial resources. SB 1256 would enact the Civility in Litigation Act, requiring one who is aggravated by the alleged unlawful act or practice to first, prior to filing a suit or pursuing alternative dispute resolution, send a letter to the person or entity alleged to have caused the harm and for the purpose of establishing good faith negotiations in order to be made whole. Of course, this bill would not apply to claims arising from related or certain violations of family code, penal code, probate code, or upon finding of true emergencies to which relief is required immediately through injunctive relief. If a claim is ultimately filed, applicants would be required to set forth in the complaint their compliance with these provisions and supply copies of their letter. Should the court fact finder or arbiter determine that these provisions were not complied with in good faith, the determination may be grounds for dismissal of the claim. Also, that would work and vice versa. So if you did make a good faith offer and you did try to do it and they chose not to make an attempt, that also would be part of it. And in attempts to comply with these provisions by persons or entities receiving the demand shall be construed as offer and compromise and shall be inadmissible as evidence or as admission of any kind. With me today, I have Hal Dansinger from CJAC to speak in behalf of the bill.
Good afternoon.
Thank you, Madam Chair and members of the committee. Hal Dassinger with the Civil Justice Association of California. We support this bill and support the early resolution of disputes. As the analysis points out, the California law, both court rules and many statutes, do encourage the settlement of disputes. We think this bill complements those laws and rules. We believe also that it will discourage the filing of abusive or nuisance claims. We believe that persons who are injured should be allowed to seek redress. However, there are instances, and we're before you quite often talking about them, where it's difficult for the defendant to afford the cost of defending even lawful conduct, and at least in some instances, the lawsuit seems to be more about money than about actually resolving the injuries of the putative plaintiff. And so we support this bill and ask respectfully for your aye vote.
Thank you. Are there other witnesses in support? Any witnesses? Please come on up. Good afternoon.
Good afternoon. My name is Vincent Passanisi. I'm a small business owner. Sorry.
Why don't you take a seat down here? You have 2 minutes.
My name is Vincent Passanisi. My company is Santa Fe Importers. We are a third-generation family-owned business established in Long Beach in 1947. We operate 3 Italian delicatessens and manufacture Italian meat products for other restaurants. In 21 years, the only times I've ever been sued were when unethical attorneys have used the law for personal gain. These lawsuits have forced us into settlements costing hundreds of thousands of dollars in order to avoid the more expensive option of going to trial. Whether we had actually violated any laws or not was irrelevant, since we were given no opportunity to address any actual grievances. Any other time another party had a grievance with us, be it a customer, a vendor, or an employee, we have been able to work things out between ourselves without having to resort to the court system. Before a company is sued, shouldn't they be given the opportunity to address and correct any putative wrongs? Shouldn't there be a meeting of the minds before a lawsuit is filed? A few years ago, a woman in a wheelchair asked us to remove a turnstile to allow her better access to our business. We gladly did that for her. Why would we want to limit our customers from shopping with us? Businesses want to do right by their customers and employees. But I've also had an attorney sue us for vague ADA violations. They forced us into a settlement without requiring us to do anything except write them a check. Is this the purpose of the law? We hold our children to a higher standard when we require them to try to work things out between themselves before calling on a parent to intervene. Shouldn't we require others in our community to do the same? For this reason, I support SB 1256. Thank you.
Thank you very much. Any other witnesses in support? Witnesses in opposition? Good afternoon.
Good afternoon, Madam Chair, members of the committee. My name is Lee Harris, and I'm Vice President and Legislative Chair for the Consumer Attorneys of California, and I'm here on behalf of the consumer attorneys to oppose this bill. And the SB 1256 is problematic for a number of reasons. It would cause further delay. We're in favor of civility in litigation, but civility is a two-sided thing, and this bill would unfortunately not promote that. It requires a plaintiff to engage in good faith settlement negotiations prior to filing an action, but it doesn't give the procedures that are involved would cause confusion and delay by requiring judges who don't have a lot of time, as it is, to become involved in these types of matters, and it doesn't set clear rules. It is based on initial uninvestigated allegations and defenses that they would have to review. It would result in increase of litigation to determine whether or not vague requirements were met in determining whether a settlement was in good faith. The bill is severely one-sided in favor of defendants. It would allow cases to be dismissed if an injured party does not negotiate in good faith, but it does not provide for similar penalties against defendants. The bill expressly protects the defendant from any actions made to comply with the procedures, but provides no similar protection for the injured party or the plaintiff. The bill requires the plaintiffs to disclose all facts and information regarding the harm suffered, but it does not require a similar disclosure from the defendant. This gives the defendant a free and early look at the case without requiring any information in exchange. Plaintiffs also are not only interested or simply interested in settlement. Sometimes it's important for society to have a wrongdoing exposed. There are many situations where wrongdoings need to be exposed, and this bill would hinder that and would not promote that good function of our litigation system. So it is dangerous and unethical to have an absolute mandate that a plaintiff make a good faith effort to settlement, particularly in cases where plaintiffs have been, for example, sexually harassed. So there are many, many reasons why this bill is one-sided, and we strongly oppose this legislation.
Thank you. Appreciate it. Other witnesses in opposition? All right. Well, as an attorney myself, and I know Senator Wieckowski and I have had our share of experiences in the court, certainly civility would be a nice thing. But I see this bill as just trying to reinforce a meme about frivolous lawsuits that go unresponded to. I know there was the ADA issue from that gentleman. That is an issue we've been working on. There have been some abuses, but I really question the need for this as well as the underlying presence. It seems that, you know, there's an undercurrent that presumes plaintiffs don't want to settle their grievances outside of court. They inundate our courts with cases that could be readily resolved. The fact of the matter is that most cases that I was ever involved in, we desperately tried to resolve them without the need for litigation. And there are a number of different mechanisms within the court system right now to get rid of frivolous lawsuits. Demurs, there are sanctions that can be imposed. The court really does have the authority to make sure that the cases that come before it are legitimate. And I just think this is a wrong-headed approach. And while I would like to see more civility, I would like to see more civility in society. And if we had that, we'd have fewer lawsuits. But I know that we're going to disagree on this, Senator Anderson, but I really find that there's very little in this bill that is supportable. I think that we have lots of ways to try to address parties that want to try to settle cases, that there are mandatory and voluntary settlement conferences that are usually required. I mean, the court does have a lot of tools available to it, and to require letters be sent, and I do also think this is a one-way bill, because, you know, it's the assumption is the plaintiff is at fault for trying to file a lawsuit. And I would suspect that when you have cases where they're taking on contingency fees, attorneys don't take cases where there's no merit to them because they ain't going to get paid. I mean, so they have to evaluate the merit or the lack of merit in a case. So I find this really more to be part of a meme, if you will, an ideological framing of issues that just doesn't reflect reality. And so I am not going to support this bill. In fact, I'm going to oppose it, and hope that my colleagues appreciate and understand that position. So, and if you'd like to respond, feel free.
Oh, well, I appreciate that. I would just like to say two quick items, and then if you would be open to it, I'd like my expert to respond to some of the technical issues. One, I'm sorry if it looks as if we're going after attorneys who are doing drive-by lawsuits. That's not the case. This bill is really given to me by a constituent who is a trial attorney, who happens to be a member of the consumer attorneys. And it was his idea that some businesses, some individuals would like to comply, and he was figuring out a way to divert them from the courts entirely and give them that first right of refusal, if you will, to comply. Because so often, the first time they get it, they're
Comply with what? What are we talking about?
Whatever the issue is, giving them that ability to take it out of the court system was his intent, and that's why he suggests this. He didn't, being an attorney, he didn't think that attorneys are necessarily nefarious. He was thinking that others may want to step up and do the right thing. And so the idea was to avoid actually getting into it so that we unclog the system by not front-loading. Having said that, I just want to give you the background and the intent, because I think it'd be very easy to think that this is pointing a finger somewhere when actually it's trying to lift people and give them an opportunity to be the best that they can be. And if you wouldn't mind addressing some of the technical aspects.
Well, very briefly, we certainly don't wish to add an additional step or a delay or clog the courts, and we recognize that this bill is not going to be a one-size-fits-all solution to what I think we can agree is an impacted court calendar for a variety of reasons. But there is a difference between filing or between working out a resolution prior to the filing of the claim and doing so afterward. And as long as the plaintiff has managed to articulate a recognized cause of action, you're in a situation where the defendant is going to either bear the cost of a defense or pay a settlement. And yeah, there are a number of settlement tools available to the court. We feel like this is an additional one that can take some of these cases out of the system prior to that additional tension that affects negotiations.
Well,
Madam,
no, let me just respond. Parties can go to mediation Voluntary mediation, that's a frequent available system that frequently parties will use if they're trying to resolve a dispute. But what is suggested by this bill, I think, is inaccurate and unrealistic and completely ignores the legal system that we have set up that does protect both plaintiffs and defendants. We have demurs, we have motions for summary judgment, we have mandatory and voluntary settlement conferences. People can go to mediation to try to resolve their disputes. They can agree to arbitrate. I mean, there are so many tools available, and part of my frustration with this bill is that it suggests that those things aren't available. And there are many different tools available. And frankly, in my experience, there is usually a good deal of communication, letters, et cetera, that go back and forth between someone who is an aggrieved party and the potential defendant that tries to rectify the situation without the need for litigation. I don't think, and the suggestion of drive-by lawsuits, I think, is an inaccurate statement for probably 99% of what lawyers do. And so as an attorney, I find myself a bit taken aback by the suggestion that it's all a bunch of nefarious folks who are out there to squeeze defendants into settling cases that are unjustifiable and that the court system doesn't protect defendants. I just think that that is an inaccurate statement, and it is disturbing to me that we are having to address this issue in this form. If there's something you don't like about the way demurs are handled, if there's something you don't like about the way settlement conferences are conducted, something we could do to improve upon them, that's one thing. But to suggest that we have to do all of this stuff before lawsuits are filed, I think simply is an unrealistic view of how litigation happens today. And so that's kind of where I'm coming from in this. Does anybody else have anything they want to say? Senator Morlock.
Thank you, Madam Chair. Not that I want to argue your point, but there was another article out today with 700 lawsuits by a husband and wife law firm in the Fresno area that are now being questioned about their justification. But I understand your points, and so I'll try it again. I'll move the item. I know I moved another one, and you were very successful in getting it pulled, but I'll move this one just to move the ball forward.
We have a motion. Is there any other discussion? Senator Anderson, if you'd like to close.
I would. I agree with you. Your premise from the very beginning that society should be more civil. And that's what this is really at the core of. You see, you may hire an attorney to sue me, but if you sent me a letter first, I may comply and make it all go away. I'm looking at that opportunity to do it. Now, a lot of people, they will turn around and they'll go first to their attorney as opposed to being just civil in our society. I want to reinforce that civility in our society by allowing this path. It doesn't take away from the court system, but everything that you suggested would require me hiring an attorney when all I really want to do is take the turnstile out so that I could have and help my customer get better selections. So this isn't about avoiding things. This isn't about being uncivil or immediately going to an arbiter or a attorney. It's about avoiding all of that by simply giving people the option of offering civility in place of it. Now, if that doesn't work, absolutely, fire up the attorneys, let's go to court, and it needs to run its natural course. But if we can keep 10% of the lawsuits out of the court because somebody was civil enough to send a letter because of this law, this bill, provided the governor signs it into law, then won't that be a good thing, not just for society, but for the courts and for everybody in this room? And that's the purpose of this bill. But I understand that for a lot of people, it's important that we use attorneys and not avoid attorneys. And that's not the goal of this bill. This bill is to empower people to be more civil in society. Thank you.
Thank you very much. Madam Secretary, the motion is to pass to the Senate floor.
Jackson?
No.
Jackson, no. Morlock? Morlock, aye. Anderson?
Aye.
Anderson, aye. Hertzberg? Leno? Monning? No. Monning, no. Wachowski? No. Wachowski, no.
Okay, you have 2 votes. The vote count is 2 to 3. We'll leave the roll open for the absent members.
Madam Chair, may I ask for reconsideration?
Well, the bill hasn't been, we haven't closed the roll yet, so at the appropriate time.